We will move to the next panel, and after the panel, we will go to lunch. I would like to invite to the stage the panelists which are going to focus on policy and regulation. So 3 lawyers will come now to the stage. The first one is Professor Niva Elkin Koren from the Faculty of Law from Tel Aviv University, Academic Director, the Chief Justice, Meir Shamgar Center of Digital Law and Innovation. And also to invite to the stage, thank you, Professor Goodman, Distinguished Professor at Rutgers and Law School of Visiting Professor at the Yale School, and Dr. Omri Rachum-Twaig from Faculty of Law from Tel Aviv University. Please come to stage. Okay, so the stage.
Thank you. Thank you very much for the introduction. My name is Niva Elkin Koren. I'm a law professor at Tel Aviv University Faculty of Law, and also directing the Shamgar Center for Digital Law and Innovation that is co-hosting this panel. We live in times of major changes. Some of these changes and disruptions we didn't welcome and we probably want to forget, but in the morning session, on the bright side, we actually heard about some exciting developments and technological breakthroughs that are actually bring some very promising trajectories. But the disruptive manner in which AI is actually affecting our social, economic, political life also brings some risks that haven't been properly discussed this morning, and we are going to discuss them at this session. It may threaten privacy and safety and security. Systems could actually amplify some of the social inequalities that we have in societies. They may discriminate. Large-scale distribution of the type of Gen AI outputs that we have seen in the previous sessions could be entertaining, but they could also help in distributing fake news, disinformation campaigns, and in a way that may destabilize democracies. Powerful persuasive tools could actually compromise consumer sovereignty, and in general, unaccountable systems can challenge the rule of law. So regulators around the world, of course, are concerned about it, and we've heard a little bit in the previous session about some of these concerns, which that actually led to what I would call like a regulatory tsunami. If there is one way to describe 2023 and 2024, is these are the years when actually regulation that was at the back seat is getting into the front seat. So OECD principles from back in 2019 have now been updated. UNESCO recommendation, the Hiroshima AI process of G7 from 2023, UN resolution, but more interesting at the national level and regional level, the EU AI Act and the US multiple regulatory measures on which we're going to hear in a few moments in more details. I'd like to make 3 points before we move to our keynote speaker. The first that is really interesting as an observation is that this policy conversation is really shifting the way in which we talked about responsible AI as a form of ethics, ethical guidelines, self-regulation, some tools that could be created by companies. And we're now moving into conversations of compliance, trustworthiness that could be measured not by the moral attitude of people, but more so by technical standards. A second issue is timing. This regulatory storm actually hits AI at a very early stage of this technology. whilst technology is still unstable and it's still in the making, as we heard throughout the day. The last time regulators had to address such a huge challenge or a revolutionary technology at the scale and scope of AI, or maybe even less so, was regarding the internet in the 90s. So in the 90s, the beginning of 2000, regulators had to address it, and they actually took a hands-off approach. They actually refrained from intervening. That created a lot of criticism. And so one of the questions now is whether this is too early to regulate, or whether we're already too late in regulating this coming technology. And the final third point that I'd like to make is that this regulatory storm is actually facing the AI environment at a moment of geopolitical crisis. So if you compare it to the 1990s and the beginning of the 2000s, when we had to address regulatory challenges related to the internet, the market and the global politics were more homogeneous. They were actually dominated by a superpower, whereas now what we see is competition among countries, among regimes, US and EU on the one hand, China, Russia and their allies on the other hand. And one of the questions is, of course, whether we could regulate technology in such a polarized ecosystem, and what are the prospects of enforcing some of these regulatory measures. We'll discuss some of these issues in our brief roundtable, but first let me invite our keynote speaker, Professor Ellen Goodman. Professor Goodman is a distinguished professor at Rutgers Law School, where she is also a co-director of the Rutgers Institute for Information Policy and Law. She's a world expert on AI, information law, studying digital platform policy, smart cities, and free speech. Recently, she has completed a 2-year mission as a senior advisor for algorithmic justice at the National Telecommunication Information Administration in the United States Department of Commerce, where she consulted on AI issues. It's a great pleasure to have you with us today.
Hello. Thanks so much for having me, inviting me, Niva, and I'm grateful to the Shamgar Center, and so happy to be here. It's such a great conference. So let's dig right in. I want to start by giving you sort of a feeling for the policy context in the US and some of the texture around the discussions. And then I'll just report out in the brief time that I have some of the highlights of what's been happening. I think I agree with Niva. It's been a storm of activity in the last couple of years. So I'll cover briefly the executive and the administrative agencies, then go to Congress, and then the states. So you might have heard that the US is having an election in 4 months. And so, you know, I have to caveat what I'm about to say with the warning that all bets are off. It's not just the presidency that is at stake, but also 1/3 of the Senate and all of the House is facing election. But with that said, there are some things that are relatively stable. The US operates under conditions of highly decentralized governance, and that is true vertically, of course, with the states having a lot of authority in the area of AI regulation, but also horizontally. So the federal government is divided into, you know, many agencies, like all national governments. But I would say with respect to AI that there's a particular particularly high degree of autonomy. And so this results in very much domain-specific examination of AI risks, and this makes it quite different from the EU AI Act, which is more of a horizontal approach. And then even within the US executive, there are, and I sort of had a front row seat to this in government, there are sort of highly contested conversations within the government with different agencies having different equities coming to bear on AI. There is no federal digital regulator in the US, unlike in the European member states. And that is a result both of an ideological commitment to, or an allergy to new federal regulatory capacities, but also I would say it's the result of 28 years of sort of a desert of digital regulation that is since the 1996 Telecommunications Act, which essentially established the laissez-faire attitude towards digital platforms and the internet. And so as a result of that, there's just not a lot of regulatory muscle in the federal government. The last couple of points, not surprisingly, US AI policy, both domestically and internationally, is inflected with the interests of US big tech companies and chip makers. There is, and that runs in many different directions, sometimes conflicting directions. There is also, there is an emerging bipartisan consensus about global competition with China, and that sort of drives AI policy as well. And then the final thing I'll say about the policy context is, as many of you know, the First Amendment jurisprudence is very restrictive in terms of how AI can be regulated, to the extent that AI outputs, and this is particularly relevant for generative AI, are considered protective speech. And we might know a lot more about that later this week when the US Supreme Court issues some major decisions in this area. Another sort of part of the texture of US AI policy discussions is what some people are calling a culture war. Not the big culture wars, but like a little culture war within the AI space that is divided along these lines. And I don't have time to really articulate who's in which camp, but just very briefly, there's the safety camp, which are also colloquially known as the doomers. And they are concerned about existential risk, and sort of shorthand for that are alignment questions, loss of human control, specifically concerns around biohazards and nuclear capabilities, both on the productive side and on the destructive hacking side with respect to critical infrastructure. And I've listed on the left some of the entities that kind of play in this space. So this is the language very much of the national security establishment. Big AI is often on this side, emphasizing these risks, their investors as well. And then this new AI Safety Institute, which is a joint US-UK initiative, is organized around existential risk and safety. Then on the other side, and I should say my own view is that these don't really need to be opposing camps. Both of these are kinds of risks, maybe at different scales and on a different time frame, but they tend to be opposing in these policy spaces, is the harms group. And they are sometimes colloquially known as the realists. And they emphasize currently existing harms, and I've listed some of them, including bias, discrimination, copyright, which was a question that came up earlier about the rights of the creative community to be compensated for, provide consent for the use of their material as training data, consumer protection, labor and the future of work, misinformation, disinformation, which all falls into a basket of information integrity. And this is where the federal agencies are really focusing their attentions. And most, not all, but most civil society organizations are emphasizing currently existing risks and harms. Let me now turn to some of the most recent developments. I think what you can see in general is that the Biden administration has created some high-level principles, and these are being articulated for, responsible AI or trustworthy AI, and these are then being articulated through the agencies, but without any new agency authority. And that's because, as I'll get to in a second, Congress has not acted to give them new authority. So first was the blueprint for an AI Bill of Rights. And this really just, again, very high level and very aspirational, walked through how existing civil and human rights apply with respect to, and it used the term algorithmic systems or algorithmic decision systems. It actually stayed away from using the term AI on purpose. An example might be the right not to be discriminated against or the right to an explanation. NIST, which is a technical organization in the Department of Commerce, works very closely with OECD. It created an AI risk management framework, totally voluntary. It is being adopted pretty broadly, and so it helps companies, other entities, sort of standardize their risk assessment, run it through their own corporate hierarchies, and it's meant to direct itself both to developers and to deployers and users. And what I'll say about this is, it has the value of being widely accepted and applauded in the private sector. It has the demerit of having no normative standards, so you can apply this risk management framework at all different levels and sort of with all different kinds of thresholds of risk. Then there are agencies such as the Federal Trade Commission and the Securities and Exchange Commission, and what they're doing is saying, we have laws, they apply to AI, and we're going to enforce them. Most significantly is the executive order that came out of the Biden administration last October. It had adopted about 150 requirements for federal agencies, and maybe of most interest here is that it's very much directed towards growing federal regulatory capacity and also immigration reform so that there is more AI capacity generally in the United States. One of the federal initiatives that I was a part of was working on developing policies for AI accountability. And this focuses on proposals through the accountability chain, so either requiring or encouraging AI disclosures and documentation, which would help, especially for developers, that would help deployers or customers or users understand what these systems are, what their limitations are, where they are fit to be used and where they shouldn't be used. And then also, further on in the value chain, evaluations, audits, red teaming, and then an overlay of liability, regulation, and market forces, which would use this documentation, these evaluations, to create actionable consequences for AI developers and deployers. Oh, he warned me that it might go back. Okay. Okay, so that's the federal government. That's the federal executive. What's happening in Congress? Very little. And so, there have been hearings over the last couple of years. You may have seen some of them, very high-profile hearings. Sam Altman, Sundar Pichai, Satya Nadella, all of the big tech execs have been brought in. Most of this has been theater. Legislators have introduced dozens of bills, some of them, modeled a bit on the EU AI Act or the Digital Services Act in the EU. None have passed. Majority Leader Chuck Schumer has essentially blocked movement of bills because he was working on this bipartisan roadmap. That was issued a couple of months ago. And frankly, it says that Congress should do what everybody knows Congress should do and has been working on, which is work in the areas listed on the right. He did say innovation, which I know we're going to talk about, is the North Star for U.S. AI policy. This was met very quickly with a shadow report, a civil society shadow report, quite scathing. And its point was that while Congress is deliberating, the rest of the world is moving on with AI regulation. This is hard to read, but I'll just summarize that it recommended that Congress address 8 areas of urgent need. And I'll just note that these involve discrimination and labor and consumer protection. Notably absent from the civil society agenda is really anything about intellectual property or innovation. So you have these 2 very different languages crosswise. I'll just conclude with some comments about what's happening in the States. You're not meant to read this. It's just a visual to show you kind of where the action is. And how many, and this is actually very underpopulated, how many bills there are in the states. So I think at last count there were about 400 new state laws proposed bearing on AI. California alone has 30. Some of these are sort of GDPR-like data protection, which laws which some states already have. Others are about generative AI and discrimination. Just to give you a flavor, 2 that have recently passed, one in Colorado and one in Utah, which gives you a sense of what's coming. I should say that California, which is often the first mover in tech regulation or in regulation generally, they have a bill that is moving pretty fast and that may be adopted, which would require safety testing and a kill switch for frontier, for the most powerful models. So this is definitely an example of the safety camp at work. Tennessee, home of country music, has passed a law protecting musicians from having their name, likeness, and musical style used in AI model training without their explicit consent. Colorado and so those are sort of oddballs. Colorado and Utah's laws, I think, are much more representative. Both are really styled as consumer protection and anti-discrimination laws. And I'll just point out that what's interesting about Colorado's is it really sort of follows this accountability chain where it relieves companies, both developers and deployers, of potential liability for discrimination if they've done the proper, and proper will be defined, to be defined by the Attorney General of Colorado, if they've done the proper risk assessment, documentation, and evaluation, enforceable only by the Attorney General, not by private rights of action. And then in Utah, it's really about disclosure. So if you're interfacing with a licensed professional, a doctor, a lawyer, an accountant, et cetera, they have to disclose when they're using generative AI. So in closing, I think we can conclude by saying that whatever happens in the 2024 election will really set the agenda for U.S. AI policy going forward, and not only because of the potential personnel changes, but also because, and this goes to what Niva was saying, what happens in the election in terms of the use of AI for persuasive or disinformation techniques, for electoral security, will also sort of set the agenda for how the public thinks about AI risks. Thank you.
Thank you, Ellen. Fascinating insights. I'd like to bring Omri into the conversation. You are representing some Israeli companies. They're looking into exporting to the United States. That is a regulatory thicket in and of itself. But they also look at Europe, where we have a completely different regime. How do they handle that?
Oh, that's a trick question. So many of them don't really handle that yet, just because of all of the confusion and ambiguity and some of the postponed kind of entry into force of various regulations. But I think before discussing how they can start looking at this, maybe we can say a few words about the European approach and how different or similar it is to various U.S. either federal or state approaches, and then see how this could affect the thought process or the internal kind of strategy and risk assessment of tech companies generally, Israel specifically. So I think when we're reviewing, so from an Israeli startup point of view, when we're reviewing the potential effect of a new regulatory regime coming up in Europe, I think we're looking at least three specific factors. One would be the scope of this new regulation, two would be the substance, what it actually requires, and three would be sanctions or liability under this regulation. And when we're reviewing the AI, the EU AI Act, we can see that each of these pillars has significant effect on Israeli startup and elsewhere. First of all, in terms of scope of applicability. So the AI Act takes, I guess, the GDPR approach or GDPR-like approach of, extraterritorial applicability, basically applicable to anyone around the world who either develops, deploys, imports, markets, uses AI systems in the EU, or with respect to EU residents, right? Individuals who are physically in the EU. This means that potentially this has, global, worldwide applicability to presumably anyone in the supply chain of developing and implementing AI systems. And by the way, the term AI system is also very broadly defined as in anything, algorithm-based, which, ranges in between sophisticated software and generative AI and machine learning, deep neural networks, etc. So this is with respect to scope. It's a very, very broad scope. In terms of, I'll skip on the substance for a second and talk about sanctions. Where we look at the sanctions, we see that here too, sanctions are dramatic. They could be ranging in between a significant percentage of the global turnaround of a company, up to 7% of the global turnover, which is a lot, but this is for a subset of the regulations, or tens of millions of euros in fines, which is obviously a consideration, right? Especially for a startup, that this could be a complete killer of its operations. And then in between these two, right, scope of applicability, understanding whether or not it applies to us, and two, what are the risks if we just ignore and don't comply, then comes in the substance, right? How to comply, what do we need to do to comply? And that's where it becomes really complex, I think, in terms of the AI Act, because the AI Act, I think, intentionally talks in a language of risk-based approach, but I think it's peculiar in the sense that it's a regulation, it applies all across the EU, it's a command and control type of regulation, but it's based on a risk-based approach. And it's based on a risk-based approach, I think, in three different ways. One is in terms of applicability. There are three categories of types of AI systems in the AI Act that have different treatment. So one type is completely prohibited, right? AI systems, so ongoing biometric AI monitoring in the public domain, for example, just as an example. The second category is high-risk AI systems, which is a very broad category, and it's a living category. So it develops over time, and regulators could I think, add to the list of categories that would constitute high-risk system, which I think poses the main focus of the AI Act and the main substantive treatment of what developers of high-risk systems should or should not do. And the third one is just general AI systems that interact with humans, right? That interact with individuals. That's one risk-based approach. I think that the other aspect of the risk-based approach is that the substantive requirements revolve around risk. They require developers, deployers, users of AI systems to conduct risk assessments and to employ safety measures based on the risks identified in these risk assessments, and take safety measures and kind of cycle back to the development stage and kind of reinforce their models vis-a-vis the risk identified. And the third part of the risk approach based is that at the end of the day, it's up to the individual organization conducting the risk assessment to assess what types of risk does its own technology create, right? So there's no overarching principle of what risks are envisaged. And I think this is, I think, first of all, it's very complex to handle. Second of all, it's almost inherently in a mismatch with a kind of command and control understanding of regulation, right? You should do that, otherwise we'll sanction you that.
Right. Wouldn't it be easier if the United States would just simply comply with that and just create some homogeneity, across the board?
Is that what we're after, easiness? So the United States is going to let Europe do its thing, and it will have the Brussels effect, and so we'll get that regulation, but on the cheap. Yeah, I mean, I think there are aspects of the EU AI Act which there's clearly alignment on, for example, a risk-based approach. I think from the standpoint of many US legislators, the problem with the EU AI Act and the reason why they're not eager to do it, anything like that, one I already mentioned is the US is organized much more in verticals. But also, at least if we look at GDPR, what the EU often does is the scope is it sort of over-regulates and under-enforces, and so the gap between the scope of the law and the amount of enforcement you can expect is big, and I think the American perspective is that's bad for innovation.
Is there any opportunities here that you see actually for innovation, just to penetrate across these different regulatory regimes?
Well, look, regulation, I think generally, specifically technological regulation, is never a real opportunity for innovation. So, but I think given that, this new regulatory framework around the world is a given and it's going to develop, I think there's an unexpected opportunity here for technology that enhances safety, that enhances compliance, that enhances, understanding the risks of various AI systems. And by the way, we see more and more startups, even some of them in Israel, yes, more and more Israeli startups. Some of them started in the fields of general trust and safety, even privacy kind of enhancement technologies that are now kind of pivoting towards AI safety, and are trying to offer various types of kind of, I wouldn't even call it, it's not really reg tech, because it's not just for the purpose of complying with a specific set of regulations, but it's a more substantive understanding or features that help you make your product safer, either by red teaming or by designing your modeling process to be bias-free, or let's say less biased than you would expect. So we see more and more technological efforts to bridge some of these ambiguities and some of these difficulties, especially for non-tech related deployers and users of technology that would get they would get a black box technology from OpenAI or whomever, and will just use it with the users. What can they do to lower the risk? What can they even do to kind of track back to the development cycle and make things better? I think this is exactly where technology could pitch in, and that's an opportunity, definitely.
Were you aware of these type of technologies emerging when in your time in the Department of Commerce? Is there any anticipation that the market will create solution for this type of compliance?
Yeah, I mean, the place that we heard, and I think this is another opportunity where we heard about actually the need for these kinds of technologies and companies was from the folks in charge of federal procurement, because I think it's really market making how much the U.S. federal government buys and uses in terms of AI, both in defense related and on the civil side. And they are hoping to take the lead on responsible AI and lack the tools that Omri was talking about to self-assess.
We didn't talk about the elephant in the room, that is a geopolitical crisis. The United States has just banned TikTok. Is there any thinking about what type of compliance technologies or AI technologies would be coming in and out, or thinking about export control for some models, or?
I don't know. It's not, it's called a TikTok ban, but it actually isn't a ban. It's just a required sale. But I do think, to your point, Niva, what went along with that TikTok ban was a prohibition on the first serious privacy regulation that we have at the federal level, which is a prohibition on selling Americans' personal data to foreign entities, and so all of that it will have to be monitored. So I assume there is some thought, but I don't know about it.
Yes.
Do we have time for questions, or?
No.
We are out of time. Please join me in thanking our panel. A lot of food for thought. Thank you very much.
So thank you very much. We would like to invite you for lunch now. So please, lunch is served, and see you after the break. Thank you very much.